All right. Thank you everyone for joining us. If you're joining us live on YouTube, we would like to welcome you to the live final round of our 2022 intramural competition. We have had quite a morning of competition here through Zoom. We've had so many wonderful judges come and volunteer their time for our competitors, and the level of advocacy has been impressive, to say the very least. These competitors have been working for months to present these arguments and to demonstrate their skills. And the teams that we have here before you today are just two of the incredible teams that have been competing all morning. So with that, I'm going to turn it over to our Executive Justice for Competitions, Lakshmi Apollinario, and she is going to get us started.
Thank you so much, Kelly. Welcome everyone to the live stream. I want to go ahead and introduce our esteemed final panel of judges. For starters, I would like to introduce Ms. Anya Marino. She is an esteemed litigator and educator that obtained her Bachelor of Arts in Anthropology from the Johns Hopkins University and her JD from the University of Maryland Francis King Carey School of Law. She was the first openly transgender woman of color to serve in a senior position for Florida's American Civil Liberties Union, the ACLU, as the Deputy Legal Director. She advocated in support of many pressing issues such as LGBTQ and voting rights. And Ms. Marino has previously taught appellate advocacy and advanced legal writing here at NSU. She helped coach our various Moot Court travel teams throughout the years, and currently she is a clinical instructor for Harvard Law School's LGBT plus advocacy program. We have Mr. Harvey Sepler. He is an appellate attorney and assistant public defender for the 11th Judicial Circuit, who has been practicing for over 30 years. He has litigated over 1,500 criminal and civil appeals in front of both the United States and Florida Supreme Court. He has taught at several law schools in Florida, including NSU, St. Thomas, the University of Miami, and he obtained his JD. Mr. Sepler is a fellow in the esteemed American Academy of Appellate Lawyers and has been awarded for his outstanding work in the appellate field by the Florida Bar, Florida Super Lawyers, and Florida Legal Elite. He has also published numerous articles and book chapters in prestigious journals, and his cases have been profiled in publications such as the New York Times and the Wall Street Journal. It's phenomenal. We have Gladys Perez Villanueva. Ms. Villanueva is a proud NSU alumnus and former county court judge for the 11th Judicial Circuit. She currently works as a professor at NSU. She is also a sole practitioner. She's a member of the Class Action and Mass Litigation Practice Group representing insurance defense matters when she worked at Schutz and Bowen. She also served as an assistant general counsel to Governor Jeb Bush and Charlie Crist, where she worked heavily with the Florida Supreme Court to resolve issues surrounding administrative law, gambling, environmental law, and other very interesting fields. Ms. Villanueva is experienced in appeals, administrative law, agency law, and civil litigation. We have returning back our former Chief Justice, Lena Apton. She is a 2021 summa cum laude graduate from NSU's Shepherd Broad College of Law. Before attending law school, she received a Bachelor of Science with a major in political science in Florida, from Florida International University, and she earned her master's degree from Johns Hopkins School of Advanced International Studies. While at NSU, she was published in the Nova Law Review, volume 44. And she was also published in the Eastern Mediterranean Health Journal in 2018. Following law school, she began working at Cole, Scott, and Cassane and is currently an associate practicing in the fields of catastrophic personal injury, PIP protection, special investigations unit, and insurance fraud defense. Lastly, but not least, we have Professor Baxter and our current Chief Justice, Kelly O'Neill. Professor Baxter is a professor at NSU. She is also the director of legal research and writing for Nova Southeastern University, Shepherd Broad College of Law. She teaches legal research and writing 1 and 2 to the 1Ls, criminal procedure, appellate advocacy for Moot Court. She is also our esteemed faculty advisor. She coaches several of our best Moot Court teams, and she's actually the recipient of the Stephanie A. Leong Impact Award in 2011 and 2018. She was also a Student Life Achievement Award finalist for 2018 and 2021. Lastly, our Chief Justice is our current Chief Justice of NSU Law Moot Court. Before law school, Kelly went to the University of Florida, where she graduated cum laude from the UF Honors Program with a dual major in political science and Spanish. In addition to serving as our esteemed Chief Justice, Kelly remains involved in a variety of on-campus organizations, such as a research assistant in the Legal Research and Writing Program. She is a member of the President's 64 and a senior associate on the ILSA Journal for Comparative Law. Outside of her academic involvement, Kelly is employed as a law clerk at De Rivera, Stevens, Black, and Kozak in complex civil litigation. Whew, I know that was a lot, but it seems like we're ready now. I'll turn it over to Kelly.
So thank you so much, Lakshmi. To provide some background for our viewers today, we are doing a team-style competition, and this is going to be a little unique from previous competitions if you've joined us for perhaps fine writer or upperclassmen. So you'll be seeing teams of two. You're going to have two issues. So Petitioner will have two competitors and Respondent will have two competitors. And with that, I'm going to hand it over to Kelly Mira, who is going to be bailiffing our round today, and she'll be bringing us into some riveting oral advocacy.
Thank you, Kelly. All right, good afternoon, everyone. I'm going to be your bailiff today. So please stay muted as I have a few housekeeping matters to address. First, please make sure you are in gallery view so that you can see everyone on the screen at the same time. If you need help with that, send an applause react. Second, please make sure you have hidden non-video participants. If you need help with that, send an applause react. At this time, please let me know if there are any conflicts of interest. Does anyone here have a conflict? Okay, looks like we're good. Okay, so I'm going to do a rebuttal check. Who is the movement in this argument?
I am, Your Honor, along with my co-counsel, George Pania. We would like to reserve 1 minute for rebuttal, taking 30 seconds out of each of our arguments, and my co-counsel will be doing the rebuttal.
Okay. And who will be the Chief Justice presiding over this matter?
I am going to appoint Justice Moreno as Chief Justice.
Okay. Okay, competitors, please keep yourselves on mute until a judge indicates it's your turn to argue. I will be keeping time using the chat function to be notifying you how much time you have left in your argument. You'll be notified at the 5-minute mark, the 3-minute mark, and the 1-minute mark. I recommend that you keep the chat function open so you do not miss any notifications. I will now say the opening remarks. Judges, if you are ready to start, I will begin the opening remarks. Once I finish opening remarks, I will turn off my video and turn it over to the judges to call the case. The timer will begin when the competitor begins speaking. Oyez, 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 all persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon. Today we are hearing argument in Taylor versus United States. Ms. Lieberman, whenever you're ready.
Chief Justice, Your Honors, and may it please the court. My name is Anna Lieberman, and I, along with my co-counsel, George Pania, represent the petitioner in this case, Jonathan Taylor. This court has presented two issues. I will be discussing the first issue, which addresses the third-party exception to the Fourth Amendment, and my co-counsel will be discussing the second issue, addressing the special needs administrative search exceptions. We request that this court reverse the district court concerning both issues. The first issue before this court is about petitioner's reasonable expectation of privacy when information has been conveyed to third parties, even in heavily regulated industries. This court should reverse the district court for two reasons. Because one, Mr. Taylor's personal medical information found within the state database is protected by the Fourth Amendment. He never consented to its release. And two, as a matter of public policy, allowing the disclosure of protected medical information in criminal cases would be a grotesque purview of justice, undermining the framers' intentions. This brings me to my first point. Searches of personal medical information are undoubtedly unreasonable. The Fourth Amendment rests upon the reasonableness of searches and seizures. Individuals.
Let me interrupt you for a moment. I apologize, but I believe you just mentioned that the petitioner did not consent to the release of the information. Is that a consideration for this court given the facts of this case and the applicable law?
Well, Your Honor, in the case of Smith versus Maryland and in the case of United States versus Miller, consent does have something to do with third-party exception. In the case of United States versus Smith, there was no reasonable expectation of privacy in that case because a subjective person would understand that a phone company can monitor your dial tones going out. In this case, Mr. Taylor he did not consent. He had no subjective belief that his personal prescription medical activity would be disclosed into the state database.
But
Also, is that actually?
Sorry, aren't all individuals charged with knowledge of the law? And wasn't he aware that his prescriptions were going into the database that the state maintained?
Your Honor, he may have been aware that the state maintained this database. However, there is a reasonable subjective and objective expectation of privacy within the Fourth Amendment, which is why we're here today.
Counselor, if you don't mind, I'm going to jump off my co-justice's question. How can there be a reasonable expectation of privacy? How can that be inferred when both federal and state statutes permit reporting private health information?
Well, Your Honor, dating back to the common law and going all the way back to Hippocrates, there has always been a strong interest in protecting personal medical information. And although Congress has allowed through the Health Insurance Portability Act, HIPAA, to allow this into state databases, in the case of a criminal case using this evidence against him of his prescription monitoring, again, goes back to the Fourth Amendment, in that we have a right within our persons to be free from unreasonable searches and seizures.
Counselor, so are you trying to say that, I'm sorry, Justice Sepler.
Oh, no, please finish what your question was.
So are you trying to say then that this particular plaintiff or petitioner in this case did not have an expectation of privacy that the state was maintaining this information? Or are you saying that the petitioner did not have an expectation of privacy that the government would use the information against him?
We are saying in this case that he had an expectation of privacy that the government would not be using this information against him in a criminal proceeding.
Now, so let me just ask, as a general theme, is it right to say that there is a right to privacy always, unless it's either waived or there's an exception? Or is it right to say that the right to privacy only exists where it is invoked, either affirmatively or implicitly, if it was implicitly by the circumstances that the society would expect that there would be a right to privacy? Which of those two is the better theme for us?
The first, Your Honor.
So the right to privacy would be there unless it's waived or unless there's an exception. The waiver part, to me, brings in the third-party doctrine. The other, the exception brings in what your co-counsel is going to argue, the special needs of the administrative. So why doesn't the third-party doctrine apply here? I mean, after all, the government didn't get these records from your client. They got them from a third party that your client acceded to allowing that to be collected, which is what you just answered to Justice Baxter. So why does the third-party doctrine apply here?
Well, Your Honor, as I said, in the cases of Smith versus Maryland and in the case of United States versus Miller, in both of those cases, the defendants had voluntarily disclosed the information, which is why the court found the exception. In this case, there was not a voluntary disclosure to the government seeking his prescription medical records.
Counselor, how is it not voluntary? He went to the pharmacy and filled the prescriptions. I mean, no one forced him to do that.
Of course, it went to the pharmacy, and there is a reasonable belief that your medical information will be sent to your physician, insurance company, and pharmacy. But allowing the government to have access to this would be an overreach of the Fourth Amendment protections.
Counselor, the government already has that authority pursuant to the state legislature and the laws enacted. So are you challenging the constitutionality of the statute, or are you challenging the constitutionality under the Fourth Amendment of the search that occurred?
At this point in time, Your Honor, we are challenging the Fourth Amendment in this particular case with Mr. Taylor, ensuring that the evidence is correctly suppressed. However, there could be a point in time where we could come back and argue the constitutionality of the state database if it's going to be used for law enforcement purposes.
But isn't the issue of the state database already resolved by this court in Wayland?
Well, Your Honor, in Wayland versus Roe, the court did discuss this, but in this case, we have a man who was just seeking out potentially for his pain to be treated and to express that an individual cannot go to their doctor and safely get prescriptions would be exactly what the framers were attempting to dissuade in writing about the Fourth Amendment.
Is it fair to really say, though, that the record reflects that Mr. Taylor was seeking palliative care? I think there are indisputable facts that were found below demonstrating that he was indeed engaged in drug trafficking, was he not?
He was engaged in distribution of these prescription pills, but there is a possibility he was using some of these for pain control. And regardless, even if this was used—
Does the record reflect any suggestion that Mr. Taylor was personally treating pain?
I'm not sure, Your Honor. I do not believe the record does reflect that.
Does the record reflect that Mr. Taylor presented any defense below beyond seeking to suppress the materials that were revealed during the DEA and law enforcement search of the database?
No, Your Honor, it does not.
Whose burden is it to assert that below?
It would be petitioner's burden.
Which is you.
Correct.
The fact that you didn't assert that, can you assert that now?
No, Your Honor, we cannot. As a matter of public policy, allowing evidence of this sort to be presented in a court of law would be a grotesque purview of justice, undermining the framers and even Hippocrates' sacred historical oath. It is without a doubt that the opioid crisis has impacted every corner of this nation. It is undoubtedly a strong interest of the government to maintain the public health of the nation. However, these interests must be balanced against the framers' intentions. The Fourth Amendment was created as a result of the misuse seen in England of individuals' property and personal rights. And by expanding the exceptions to the Fourth Amendment to situations in which an individual's property has been disclosed involuntary via a statute, would allow the government to severely overreach their boundaries, which have been carefully—
It would be reasonable for your client to assume that when the information goes to the pharmacy, that the pharmacy would keep records. And that would be reasonable, wouldn't it?
Yes, Your Honor.
Okay. And he didn't seek to limit that. He didn't say, well, I understand the pharmacy, you're going to be filling a prescription, but you can't do these things with it. He didn't do that, did he?
Your Honor, I see that my time has expired. May I have a moment to respond to your question and then briefly conclude?
Ask the chief.
You may respond, and indeed, I actually have one additional question as well.
Thank you, Chief Justice. Your Honor, no, he did not. However, I would say that there is no subjective nor objective expectation that your pharmaceutical records will be transmitted to the state for criminal proceedings.
I want to briefly touch on the issue of the framers' intent, because you suggest that we should consider that when disposing of this case. This court has already previously, in some instances, receded from what the framers' original intent is when interpreting the Fourth Amendment. Indeed, perhaps the most clear example of that would be Terry versus Ohio. So why does this case present an exception to, or rather present different facts or circumstances that would lead to a different result where we don't recognize an exception here?
Well, Your Honor, Terry versus Ohio was more about seeing suspects acting suspiciously. There was probable cause that something was going on in that case. Here, the petitioner was simply filling prescription drugs, and this could have been any individual. It did not have to be Mr. Taylor. If we were to expand this, it would allow the government to look into your prescription drug activity. And what's to say they couldn't expand that beyond controlled substances into everyday prescriptions like diabetic medication? For those reasons, we request that this court reverse the district court's decision. Mr. Taylor had a strong expectation of privacy in his non-consensually released medical records, and as a matter of public policy, disclosure would create a dangerous overreach of governmental searches, undermining the justice system and the framers' intentions. Thank you, Your Honors.
Thank you, Mr. Bonilla, please.
Chief Justice, Your Honors, may it please the court. My name is George Pania, and I represent the petitioner, Mr. Jonathan Taylor. Now, as my co-counsel, Ms. Lieberman, stated, I will be addressing the second certified issue as to whether the administrative search and special needs exceptions to the probable cause and warrant requirements under the Fourth Amendment applied to the DEA and Highland Sheriff's Department search of the state database of controlled substance prescriptions. Your Honors, it was error to hold that the administrative search and special needs exceptions apply to the case at bar, where the DEA and Sheriff's Department were simply concerned with a general interest in crime, and where the act fails to allow for pre-compliance review or even offer a constitutionally adequate substitute for warrants. Therefore, we respectfully—
Counselor, can I jump in here? Do you have to win on both of these issues to prevail, or just one?
Well, Your Honor, my co-counsel's issues is a threshold question. However, in the event that this court would hold that the DEA's access to the database was a search, then my issue would then come to effect as to whether the fact that the DEA and Sheriff's Department are not, I guess, protected by the administrative search and special needs exceptions to their warrantless search.
So if we were to disagree with your co-counsel and find that this wasn't a search, we don't need to reach your issue, right?
That is correct, Your Honor. However, in the event that this court does hold that it was a search, and we would ask that you reverse and remand the decision of the circuit court for the following two reasons. First, the DEA and Sheriff's Department search was pretextual, and the act allows law enforcement agencies unfettered discretion to access the database. And second, as a matter of public policy, holding that the administrative search and special needs exceptions apply would only overbroaden the scope of the few and well-delineated exceptions to the Fourth Amendment's probable cause and warrant requirements to include—
Counselor, sorry to interrupt you, but isn't it very important for the government to have access to these prescriptions to prevent dangers that drugs present to the community at large and drug traffickers?
Yes, Your Honor, which brings me to my first point, is that the act fails the New York versus Berger test, which states that if an administrative search involves a closely regulated industry, warrantless inspections must be necessary to further substantial government interest, and the regulatory scheme must offer a constitutionally adequate substitute for a warrant. Now, with respect to this point, an administrative search is one that is conducted to further administrative goals pursuant to a legislative scheme. Now, in this case, the DEA and Sheriff's Department access the database with the one specific goal of securing evidence of a crime. Now, further, even if this court were to deem the DEA and Sheriff's Department search falls under the purview of the administrative and special needs, the act would fail again under the New York versus Berger test. Now, the Fifth Circuit in Kotropia versus Chapman held that the medical industry as a whole is not a closely regulated industry, but it did leave the door open because the prescription of opioids might be. Now, however, in that case, just as in this case, the regulatory scheme failed to provide a constitutionally adequate substitute for a warrant because it did not limit the discretion of the inspecting officer by positing a limit on whose records could be subpoenaed or even how clinics are chosen in that case. Now, further—
If I may, Counselor, I want to follow in.
I'm sorry. Regarding the law enforcement aspect you were just speaking of, you made a comment that law enforcement has unfettered discretion to conduct the search, correct?
That is correct, Your Honor.
Is that not a facial challenge to the statute versus a Fourth Amendment challenge to the actual search? And if so, was that matter preserved below? I didn't see that in the record.
No, Your Honor, the matter was not preserved below. And in this case, this argument right now, we're not arguing as a facial challenge, just to the application as to Mr. Taylor and in his criminal conviction.
So just to clarify, counsel, you're doing an as-applied challenge to the statute. Is that correct?
That is correct, Chief Justice. Now, further, the Fifth Circuit in Cotropia versus Chapman held that, unlike this case, the defendant's search was not pretextual because it served an administrative purpose, such as taking disciplinary action, issuing administrative penalties, and seeking injunctions. Now, further, in this court in Delaware v. Prost held that unless there's some violation of a law stopping an individual to check his driver's license, his or her driver's license, and registration is unreasonable under the Fourth Amendment. Now, notably on page 654 and 655 of that opinion, the court stated that one of the Fourth Amendment's essential purposes was to place a reasonableness standard upon the exercise of discretion by government officials in order to safeguard the privacy and security of individuals against arbitrary invasions.
Counselor, let me just stop you here for a second. Isn't the whole, as they say, the bottom line purpose for this whole series of investigations is protection of the public, not only protection of individuals, but protection of the public. So the actions of law enforcement in investigating this database were to further a legitimate public purpose. Was it not? Were they not? It may have been also to arrest people who were breaking the law, but it was also to further a legitimate public purpose.
Your Honor, I would respectfully disagree. While the act does allow police and purports to have that purpose in mind in ensuring the health and safety of its population, here the Sheriff's Department initially searched the database looking for an illicit source of opioid drugs amongst the local doctors. Now, only after coming across nothing suspicious in the prescription patterns of the doctors, the DEA and Sheriff's Department then started looking into the patients. Now, the DEA and Sheriff's Department had absolutely no constraint and looked through the database with unbridled discretion while not acting any under guidelines, standards, or procedures promulgated by any higher authority. Therefore, as the Supreme Court stated in this opinion, Delaware v. Prost, this is exactly the kind of standardless and unconstrained discretion that this court has discerned when in previous cases has insisted that the discretion of the official in the field be circumscribed. Now, as to my final point, Your Honors, as a matter of public policy, Your Honor, did you have a question?
Well, it seems to, in all candor, counsel, you seem to be selling the government's position short. I understand, I think we all understand that they were looking to stop wrongdoers, but they were also looking, the government has also looking to help the public safety. So I think it really sells their position short to say they were trying to find wrongdoers and only wrongdoers. I don't think that's correct. They were trying to find wrongdoers to help public safety. So would your position be any different if there was no other way for the government to get the information that they're seeking than to look at the database of the pharmacies? Would your Honor, be different?
No, I would respectfully disagree, simply because the DEA and Sheriff's Department only access the database after a criminal investigation has been initiated. Now, the DEA and Sheriff's Department had access to the database just as a regulatory thing, or if it was an monthly inspection, then I would concede that they were looking out for the health and safety. However, they only access that database after a criminal investigation. Therefore, their only intent was to secure evidence of a crime. Now, as to my final point, Your Honors, as a matter of public policy, to hold that the
Counselor,
administration.
so I understand. So you're distinguishing this then from the checkpoint cases, in those cases, similar to that, drug testing cases, checkpoint cases. You think this is different than those cases somehow?
Yes, Your Honor. And actually, Delaware v. Prost is a checkpoint case. Now, in that case, the Supreme Court, this court stated that a reasonable standard requires some measurement based on an objective standard, which requires individualized suspicion. Again, the DEA and Sheriff's Department had no suspicion about Mr. Taylor, and they never did up until they started then looking after they looked at the doctor's prescribing practices.
So would you be okay with this if it didn't get rid of probable cause? So if probable cause was still required, but it was just one of the well delineated exceptions to the search warrant requirement, you would be okay with that, and you think that it would fall within there? I'm just trying to find where we draw the line, Counselor.
Your Honor, I see that my time has expired. May I have time to briefly answer your question and then conclude?
You need to address the Chief Justice.
I'm sorry?
Mr. Petitioner may respond to Justice Baxter.
Thank you, Chief Justice. Now, Justice Baxter, where I would draw the line is if, in this instance, that if the police had probable cause, they would have no issue getting a warrant. The database is held in a central location by the state. Therefore, there's no special need. There's no exigent circumstances that would require the police to forego the probable cause and warrant requirements. However, in this case, Mr. Taylor was never under suspicion. They just happened to be looking at this database pursuant to a very broad and unconstrained criminal investigation, and that's how they came upon Mr. Taylor.
May I, Chief Justice, may I ask one final question and then I'm done?
You may, Justice Sepler.
Counselor, what would your position be if the government was looking for doctors that are practicing without a license? And how they're going to find out who those doctors are is they want information from insurance companies about bills that have been given to the insurance company to reimburse for medical services. And the insurance company gave the information over. Would your position be the exact same if it was that rather than pharmacies?
No, my position would not be the same because in that hypothetical, the insurance company gave that over. It's a private actor gave it over to the state actor as opposed to the state actor just coming in whenever it wanted and then gaining that information that way. Your Honor, Chief Justice, may I have a brief moment to conclude?
You may.
Thank you, Chief Justice. For the foregoing reasons, we respectfully request that this court reverse the decision of the Circuit Court as a DEA and Sheriff's Department search was pretextual and unconstrained, and expanding the special needs and administrative search exceptions to include searches pursuant to any criminal investigation would violate the Fourth Amendment. Thank you.
Thank you, counsel. Mr. Sciarra.
Chief Justice, Justice Associate, and may please the court. Good afternoon. My name is Alessio Sciarra, and alongside with my co-counsel, Ashley Montalvo, represent the respondent in this proceeding, the United States of America. This court has presented two issues. I will be discussing the first issue, which addresses the expectation of privacy in prescription drugs record under the Fourth Amendment. And my co-counsel will be discussing the second issue, addressing the administrative search and the special need exception. We respectfully request this court to affirm the Court of Appeals decision concerning both issues for two reasons. First, under the circumstances of the case, the petitioner has no reasonable expectation of privacy in prescription drug record held in the database of controlled substances under the Fourth Amendment. Second, the administrative search and special need exception apply in the case at issue. Moving to my argument, it will proceed in 2 points. The first point is that the petitioner has no reasonable expectation of privacy in prescription drug record because of the content, the nature, the characteristic, and the function of those records. The second point is that the third-party doctrine applies and preclude the petitioner reasonable expectation of privacy.
Counselor, go ahead, Chief Justice.
Doesn't both federal law and several states recognize the privacy rights of individuals regarding their medical information. For example, under federal law, we have HIPAA, and several states also have state analogs that even provide greater protections such that individuals can rely on laws to protect against unwanted disclosure of their medical information.
Yes, Your Honor, I see your concern, but it's necessary to make a big distinction. This distinction is between drug prescription record and medical records. Medical record.
Doesn't the statute actually reflect that drug records, prescription drug records are actually medical records? Indeed, mental health records are considered medical records under the statute.
Yes, but we are not contesting the right of privacy in those records. We're saying that the content of the police enforcement was not a search under the Fourth Amendment, because in the
well, let me ask you this, counsel. Under HIPAA and several of the state analogs, in a civil matter, to actually gain access to the records, it either requires a voluntary disclosure of the patient or a court order. So why would we not require a neutral arbitrator to determine whether it is indeed reasonable to review an individual's records in this instance?
Yes, there are two prongs on the test. One is the reasonable expectation. So whether the petitioner subjective expectation was to disclose those information or not. But the second prong that it's at issue here, it's whether the petitioner expectation of privacy is reasonable. And here, the expectation of privacy was not reasonable because the information contained in the prescription drug record are very little the information regarding to the patient. Most information are related.
So Counselor, to make your argument, you're having to say that the petitioner, that society is not ready to accept as reasonable the belief that when you put a prescription to the pharmacy, that pharmacy doesn't turn it over to the cops, right? So that's a little bit of a difference. So yes, certainly they gave up their expectation of privacy there when you're talking about to the pharmacy, of course, right? But is it reasonable for us really to expect that the pharmacy is going to turn that information over to the government to use against them? And isn't this more like, I'm going to add on to that, sorry. And isn't this more like Carpenter with our cell service location information, right? Where you don't really have a choice. You don't have anywhere else to go to get your prescriptions filled. You have to go to the pharmacy. You have to turn over that information to be able to get those prescriptions. And so I'll let you answer that. So isn't this more like Carpenter? Let's start with that one.
Yes, the case was similar, but in Carpenter, we are dealing with medical record. We're not dealing with drug prescription record. And even if
Carpenter, we're dealing with cell service location information, right? We were dealing, and so what we said in that case is that it's reasonable to expect that the government isn't going to track your every move, right? So, and you don't have a point, you don't have a choice. Everybody has a cell phone these days, right? It's compulsory. So isn't turning over your medical, your pharmacy records, your prescription records, it's compulsory. You have no other choice, right?
Yeah, I think here the issue is what type of information the petitioner is trying to protect. Because in the drug prescription record, there is only the first name and the last name of the patient, and it's accompanied by the name of the drug, the quantity of the drug.
Right, and doesn't that give a lot of information? That's what the drug is, right? And that gives a lot of information.
To just piggyback off what Justice Baxter asserted, doesn't that information also include certain ICD codes, in essence, the underlying diagnosis for specific prescription drugs? Indeed, it would have to, because to process any prescription order and to determine whether an insurance company would pay out, it would have to have an ICD code associated with it. So there would be the actual underlying diagnosis would be revealed in any of these disclosures.
No, Your Honor, I disagree, because here we are dealing with specific drugs that are Percocet and Oxycontin. They are opioids. So in that case, they have a very...
Counselor, let me just.
If I understand your argument correctly, it is your position today that this court should overrule Carpenter that dealt with cell phone towers with anonymous technological information that is way beyond my understanding, and overrule that where we ruled that that was a reasonable expectation of privacy, and hold that medical records, that we have a plethora of laws to protect, and prescription drugs may be included as in the definition of medical records, we do not have an expectation of privacy.
I think it's necessary to make a distinction between Carpenter about the type of information whereby the petitioner is seeking to protect. In that case, it was a GPS case, so the police enforcement was able to tracking the position of the defendant.
But do you not think it's stronger to have, do you not think that this case is stronger for privacy than Carpenter?
I think in this case, the particular drug makes the difference. And here it's not possible to interfere the type of disease that the petitioner has from the drugs.
But it's all class 2 drugs, correct? So it could also potentially include any drugs that are class 2 that may be something like benzodiazepines, for which many individuals are prescribed those pills to treat mental health issues. Are you suggesting all of that information should be readily available to the public and to law enforcement?
I'm saying that that type of drug, this type of drugs, including classified as Schedule 2, are at a very general function. They usually affect the central nervous system, so they merely alleviate the pain. It could be used for back pain, or it could be used to.
So let me ask you a question. Has this court ever held that the Fourth Amendment has essentially a harmlessness feature to it? That is that the evidence that we're talking about really isn't so bad. It may be protected, but it's not so bad. So we can overlook an infringement of the Fourth Amendment if what's being revealed is rather innocuous, like names and addresses. But it becomes more important when it's something. Have we ever held that that was the case? A Fourth Amendment violation is a Fourth Amendment violation, no matter what it is that the government is seeking. Isn't that correct?
Yes, but in this case, it was not a Fourth Amendment violation because the cat's test was not satisfied, because the petitioner had no reasonable expectation of privacy. So in order to consider the police enforcement conduct as a search, it's necessary to satisfy both the prong of the cat's test. And
but Counselor, I'm sorry to interrupt you, but just to touch on the public policy aspect of all of this, wouldn't this holding undermine the trust inherent in the confidential doctor-patient relationship?
I see that my time has expired. Okay, I have a brief moment to answer your question and conclude.
You may answer, Mr. Shara.
We consider that the public policy is in favor of the respondent position. In this case, there is not only the need to protect the right of privacy, but also the need to protect the safety and health of the American citizen. And there is a big crisis related to the sale of opioids in Fort Lauderdale at this moment. For this reason, we respectfully request this court to affirm the Court of Appeal decision because the petitioner has no reasonable expectation of privacy. Thank you.
Thank you, counsel. Ms. Montalvo.
Chief Justice Marino, Associate Justices, and may it please the court. As my co-counsel, Mr. Alessio Chiara, previously stated, my name is Ashley Montalvo, and I also represent the respondent in this matter, the United States government. We respectfully request that this court affirm the Court of Appeals decision because both the administrative search and the special needs exception to the probable cause and warrant requirements under the Fourth Amendment apply to the search of state databases that contain information of controlled substance prescriptions. Additionally, as a matter of public policy, we must recognize that the actions taken by the DEA agents in this case were lawful in combating the opioid crisis, as was the legislative intent in the enactment of the Controlled Substance Act itself.
Counselor, why do you suggest that the administrative search exception applies here?
Yes, Your Honor. In looking at New York versus Berger, the 1987 Supreme Court case decision, in that case, the court held that when we're dealing with a highly regulated industry, there is an administrative search that would allow warrantless search through these databases, which in looking at the case at hand today, the healthcare industry and pharmaceuticals, such as these prescriptions, are part of that highly regulated industry, and is why the administrative search exception to the rule applies here today.
Well, given the expansion of the regulatory state, could it not be argued that essentially any area would be a highly regulated area for which the government can go ahead and intrude on people's privacy?
Not necessarily, Your Honor. Here, we're focusing on the pharmaceuticals, which have the chilling effect, as is seen here, that the opioid crisis is taking into effect and taking the lives of over thousands and thousands of individuals, which has posed the reality as to why we must have these administrative search exceptions apply when dealing with heavily regulated industries. If we take
I'm going to hop in, Counselor, I apologize. You might have noticed my concern when I was addressing this with your opposing counsel. So I think that it's pretty reasonable to have an exception where we do away with the warrant requirement. We have lots of those, so many so that mostly they've kind of swallowed the original rule, right? But my concern really comes from us dispensing with the probable cause requirement. So can you explain to me why that should apply here? Why we should dispense with the probable cause requirement?
Yes, Your Honor. So the reason why we should allow this administrative search exception to apply here and not focus so much on the probable cause is because under the Controlled Substance Act itself, specifically 21 U.S. Code Section 876, subsection A, allows these DEA agents to have the opportunity to look through these databases to combat the opioid crisis. It's different if we take a step back.
Well, I actually have a question about that. Can a statute override certain constitutional protections?
In this case, it's our position that it does, and that the DEA agents didn't operate with unfettered discretion.
Let me make sure I understand. You're saying that Congress maintains the authority to override the most supreme law of the United States?
No, so now that I understand your question, Chief Justice, the right to privacy is fundamental, and we're not discrediting that here today. However, we are holding the position that the petitioner in this case, Jonathan Taylor, did not have that reasonable expectation of privacy here. If we look at the situation and the facts as evidence on page 6 of the record, Jonathan Taylor was not a patient who simply walked into one doctor seeking a prescription from a doctor to treat one ailment. Rather, Mr. Taylor, the petitioner, went to multiple doctors, and he saw—
I'm sorry, just to interrupt you. So just to piggyback off the Chief Justice's question. So I think what you're saying then is that the statute doesn't actually override the Fourth Amendment. You're saying that the statute fits within the Fourth Amendment? Is that the argument that you're making?
Yes, that they should, yes, Your Honor, that they should be viewed together. And
okay, I'm gonna go back to my probable cause question then, because I don't think you quite answered that. I apologize. I'm still not satisfied with that answer. So a lot of the administrative search question cases, we have gotten rid of the probable cause requirement because it wasn't feasible to require probable cause, right? Such as the drug testing cases and the high school drug testing cases and the checkpoint cases, right? But tell me why here it's not feasible to require the government to have probable cause before they get this information from the pharmacy.
So, Your Honor, here in this case at issue, the DEA agents had the authority under the statute to look through the database itself. And they first started with looking at the doctors. They didn't pinpoint patient information. They first started there and then they worked their way down to the patient information contained in the prescription drug records.
So I'm sorry to belabor this point, but so then why at that point couldn't they go get a warrant?
I understand your concern there, Your Honor. However, I think it goes to the fact that when we have rules, there are exceptions. And if we're not going to follow the exceptions or allow them to have the space to function, then why have the exceptions at all? Why not just follow a steady rule? Which I think was the point in the Supreme Court holding of the 2001 case of Ferguson versus City of Charleston in relation to the special needs exception. Here in this case, the petitioner, here in this case, the special needs exception applies because the DEA agents are trying to combat the opioid crisis, which as a matter of
last question about special needs, is it not that special needs cannot be related to solely law enforcement purposes? And I'm having a difficult time understanding something in this case, and perhaps you could clarify it for me. I believe you argued that the purpose of this administrative search was the opioid crisis. Then why are we here on a prosecution for distribution of a patient?
Yes, Your Honor. So we are here today because the petitioner was engaging in the exact conduct that the Controlled Substance Act itself is trying.
I understand, but my question is, if you're arguing special needs and special needs prohibits that the special needs are only directed to, it cannot be directed solely to law enforcement, and the stated reason for the special needs is the opioid crisis and prescriptions, right? Doctors writing prescriptions. We're not here on a doctor writing prescription. Do you not think that the fact that we're here on the prosecution of the petitioner undermines your argument?
No, Your Honor. I think it actually further strengthens our position as a whole. We are here arguing on behalf of the United States government, and under that, the Controlled Substance Act itself that was enacted by legislature was meant to combat this opioid crisis, and the DEA agents were the vehicle to execute that legislative goal here today.
Couldn't the DEA have simply sought records that demonstrated the number of prescriptions a physician wrote? Was it necessary to actually acquire additional data and information that revealed the particular patients to whom these prescriptions were written, and any other medical information that may actually be included in this database?
Yes, Your Honor, it was necessary here because if we look at the facts as well, the DEA agents did look first to the doctors who were prescribing these medications. But to that avail, doctors have multiple patients coming into their offices on a day-to-day, and it makes it a little bit more challenging to trace back whether the illegitimate or trafficking or abuse of these prescriptions.
But aren't there other ways for law enforcement to actually monitor illegal conduct that doesn't involve an intrusive search into a large database of people's private medical information? Let's assume, for the sake of argument, that law enforcement went ahead and actually was able to identify a specific doctor who was issuing enormous amounts of prescriptions for opioids. Wouldn't that, in that instance, have triggered law enforcement to at least have conducted some type of surveillance of that doctor's practice to see if there were indeed specific patients who were accessing that doctor's services, as opposed to simply engaging in a suspicionless search of a database?
Chief Justice, I see that my time has expired. May I have a moment to answer your question and then briefly conclude?
And if I may, Chief Justice, after she finishes that, I did have one question to ask her.
You may ask Justice Zuckler.
Do you want to, why don't you finish the Chief's question and then I will ask?
Yes, Your Honor. Chief Justice, to answer your question, I think that the proposal that you are recommending is valid. However, and it was an avenue that the DEA agents first did try to pursue here when looking at the doctors and the information they were inputting into the database. However, that did not turn up into anything to help further the cause of combating the opioid crisis, which is why the DEA agents further looked into what the patients who were having multiple patterns of prescriptions from varying doctors, which kind of signaled to the DEA agents that something was not entirely wrong. And at that point, further solidified the pursuit of the petitioner in this case specifically.
Okay, let me just ask you a question because I know your time has already expired. As I understand it, of course, co-counsel argued that there wasn't a right to privacy. We're going to put that aside for a moment. That you're arguing that even if there were a right of privacy, you fall under the exception of the administrative searches or the special needs searches. Am I correct on that?
Yes, you're correct, Your Honor.
In the 2000, you quoted the Berger case, which I think was 1987. Yet in 2015, when we decided the Patel case, we said that the administrative search, only one of the factors, one of the necessary factors for the administrative search to apply is where there is a pre-compliance review. We also said in that case that in order for the special needs exception to apply, one of the necessary factors is that the search must further the regulatory scheme. So if those two factors are not satisfied, neither of those exceptions apply, and then your argument at least will not succeed. Is that correct?
That is correct, which is why we have argued today before this court that the petitioner here did not have a reasonable expectation of privacy, and that both the administrative search and special needs exceptions did apply here today. And which is why we are respectfully asking this court to affirm the Court of Appeals decision and hold that the petitioner did not have a reasonable expectation of privacy, and that both the administrative search and the special needs search apply to the case at issue here today. Thank you.
Thank you, counsel. We'll hear argument from the petitioner again, who is presenting rebuttal.
I am, Chief Justice.
Mr. Pinilla, whenever you're ready.
Thank you. Just because the DEA agents had authority under the Act doesn't mean that they had authority under the supreme law of the land, the United States Constitution. Now, just as Justice Baxter mentioned, this court in Carpenter v. United States held that a defendant had a reasonable expectation in his location stored by a cell phone provider because a cell phone is an essential part of society, and it cannot be said that he voluntarily conveyed that information. Now, in this case, seeking medical treatment is an essential part of society. It cannot be said that Mr. Taylor voluntarily gave his information away because he was required to do so in order to receive the medications he required. Now, as such, the DEA and Sheriff's Department's unconstrained, broad, and suspicionless search that was indistinguishable from a general interest in crime control violated Mr. Taylor's Fourth Amendment rights against arbitrary government invasion. Therefore, we respectfully request this court reverse and remand the circuit court's decision. Thank you.
Thank you, counsel. The case has been submitted.
Thank you, everyone. Wow. Congratulations to all of our competitors. That was a really, really impressive round. You should pat yourselves on the back. At this point, I am going to take the rest of my final panel along with me to the judge's room to deliberate. And I'm going to turn it over to our Executive Justice for Competitions, Lakshmi Polinario. She has some really important announcements to make in the meantime. So stick with us and we will be announcing a winner shortly.
Hey everyone, let's wait for the judges to go on and move into the judges' lounge. Just waiting. Justice Abden, you're welcome. You're already assigned to the judges lounge. You just have to move into the room. Same for Chief Justice Marino. You are already assigned to the judges lounge, so you should be able to get into the breakout room.
I'm just showing an ability to leave the meeting, but I didn't receive an invitation to the breakout room.
1 second. Let me go ahead and move you somewhere else. And now
I have it now.
Not yet. Not yet. Now. Uh-oh. Oh, no.
We'll be back shortly.
She's good now. She's in there.
I'm back.
Try again. Hold on. Because I have to assign you to one room and then assign you to another because I had this glitch happen earlier. So
No.
yeah. So hold on. So and now you should be in the judges lounge. Oh my goodness. Okay. Hopefully that worked. You moved too quick. You have to give me a second because I have to assign you twice. I'm so sorry.
No worries. I'm just simply pressing the invitation to join and then it's returning me here.
Okay. So don't click the invitation to join yet, okay?
Understood.
Got it. So now I'm gonna send another invitation and that should work. Try that now.
I believe that will work now. Thank you.
That's my cue. I'll catch up with you shortly.
Okay, wow. Let's give you guys a round of applause, please. Go ahead and unmute yourselves. I want to hear real applauses. I'm not allowed to use sound effects anymore. So I have to, please everyone unmute, unmute, unmute. I have a lot of questions for all of you. Let's give a real round of applause. I'm so proud of everyone that is on the screen right now. I know that many of you had no idea that you were gonna make it this far. And I wanna start with the wolf pack. I wanna know how you guys feel. Let's start with Ashley.
I feel excited that it's finally like we got through it. And I couldn't have asked for a better teammates for this competition. So shout out to Alessio and Jake.
What's cool, a little bit of background information about the wolf pack. They got paired together. They didn't really know each other before this. They didn't know each other that well. And then they were paired together by us, by the e-board, because we noticed that they hadn't actually been able to pick a team yet. So when we paired them together, the fact that you guys made it so far is absolutely amazing. And there's a lot of chat going on in the chat. I'm gonna address that, but I do want to hear from Alessio and then Jake.
I didn't expect to go so far, so I'm really happy. And let's see the result. I mean, I'm happy in any case.
Jake?
Yep, exactly the same. I'm very happy with our team. I honestly, I had confidence in us. I thought we were getting great feedback all day from the judges. I couldn't ask for a better team. I know Ashley. I know I've been around Alessio in the classroom. I know that they're both very intelligent people. I, of course, wish I could compete in the final round, but I was very, very happy with their performance. They did great. So I commend them.
Great job. And what a lot of people don't know is that we had an uneven amount of competitors. So they are the only team of 3. And that is why they are called the Wolfpack. I'm getting information from the deliberation room. Okay, it's kind of intense in there. Okay, let's focus. So I do want to hear from Team Boston Legal. I'm proud of you guys. Tell me how you feel.
Anna, you want to go first?
I guess I'll go first. I didn't expect to make it to the finals at all. But George, it's been rad working with you and working around your crazy competition schedule. So I, like Ashley said about her teammates, I couldn't have asked for a better teammate, and you already know that. So
Oh, shucks. Yeah, I mean, I definitely did not. I'm just as surprised as all of you to be in the final round. I'm rather tired from the other one. But it's been fun. It's been fun. And Anna's been an absolute beast and super reliable. So That's all you can want in a teammate.
Thanks, dude.
Yeah. Good job, dudes. Okay, so let's see what's going on in the chat because people love when I shout them out. So we have Rachel Trodigot. She is a stellar Moody. She said woohoo.
She's so sweet.
Connor O'Neill, that is actually our Chief Justice's cousin. She came through to represent for the fam. And I responded and I said, our Chief Justice is the GOAT. Okay. We have Professor James Willits. He has been avid in the chat. He said, great job, everyone. What else he said? He was talking about their privilege. He was talking about one of you guys' oral arguments. So he was kind of in the chat like he was a judge too, because he was paying attention. Okay. We also have Gabriela Guzman, who was a Moody judge, former national competitor and winner for a Best Brief Award. She said that you guys were so impressive and congratulations. We have someone named David Linares. Do you guys know who that is? We don't know who that is. I don't know who that is either. Maybe David will tell us in the chat, but he's here and he said, amazing job. We have Joe Stanley, who is one of the best supporters of Moot Court. She is at every single competition that we have. She actually judged me during my fine writer competition. And she's always in the semifinal round. She's brilliant and she asks the most phenomenal questions. She also said, having been chief of the panel that sent the Wolfpack through to the finals, they did us proud. Tear to my eye. So proud. Let's see. Okay, so that's all that we have for announcements from the chat. I do want to hear from Melissa and Kelly. Both of them, Kelly Mara, both of them are actually justices for competitions. They work with me. We are the ones that are the backbone of this competition. We are the ones that work tirelessly for 2 months to make this happen. So I do want to hear what Kelly and Melissa have to say.
Sure, I'll go ahead, Melissa. Thank you guys for being here, and for everyone who's watching, thank you for taking the time to support all of our Moody members. I know I had Anna and George yesterday. We had a little practice session. Good job, guys. I'm really proud of you guys. You guys really pulled through, and I knew it the whole time. I knew you guys were gonna make it here. So congrats with that. To the Wolfpack, I know I have had all 3 of you in my classes, and I will say you guys are all very intelligent people, and I'm not surprised. And especially being a team of 3, I know that's probably, people probably think it's easier. It's probably not. So congratulations, everyone that made it here deserved and earned every step of the way. So I'm really proud. You guys represent Moot Court very well, and thank you for making our job worth it.
Thank you.
Yeah, I second everything that Kelly said. Really awesome. That was a really good final round. You guys both teams did amazing. It's been an honor and a privilege to work with Lakshmi and Kelly and Jordan to plan this competition and see how it all came out. And I'm incredibly proud of all of you, and I'm excited to see who won.
So just so we know, we found out that David is actually an L1L, so he's a 1L in the evening division. He said he came through to represent for Dean Cross. And then Professor Willits, he checked me. He said he wasn't talking about your argument. He said that it's a privilege to join us, and we just want to thank you because it's a privilege that you're here. Seriously. Scott Palmer was part of our scoring division. They scored over 200. They made over 200 calculations for 3 rounds, 12 competitors, and that's a lot of math that is above my pay grade. Okay. And okay, so let me go ahead and share my screen. I do have a minor presentation for everyone. Okay, if you can see my screen, give me a thumbs up. Phenomenal. So first and foremost, can you still see it? What in the world? Hold on a second. It had subtitles? Never seen that before. Okay. Sometimes we have hiccups, and that is okay. Okay, now you guys can see my screen, right? Okay, perfect. Thanks so much. Okay, so here we have everyone that competed. We have all of our team names. I thought it was a great idea. I really wanted to personalize everything. So we have our team names. This is everyone that was able to compete today. The Boniatos, they made it to the semifinal round. They were phenomenal. We had our two Mooties, the Mighty Mooties, the Phenomenal Wolfpack, the Cool Cats, Boston Legal, who we have right here, right now on our screen. We had J&J Litigators. That was a very funny name. Monty Paulton, I thought that was super original. The A-Team, the two Utes. We had the Breakfast Club come through, show up and show down, Sharknado. So that was cool. And then now we're going to show our semifinalists. A big shout out to Monty Paulton, Boniatos. They were phenomenal. And the fact that they didn't make it here was literally by the small hair on my chinny chin chin. Above all, we definitely want to say thank you so much to the judges that volunteered. This competition, it cannot be done without you guys. We had over 60 judges come and volunteer. We also had 5 judges in each room because we wanted to make sure that we had a hot bench for these very, very advanced competitors. I want to thank our scoring division, Scott Palmer and Jonathan Bornstein. Without them, nobody would be able to figure out those numbers because I definitely can't. So let's just say that. And I also want to give a huge, huge thank you to our brief grading committee. Without them, we would not be able to actually have our briefs scored. And last but not least, I would like to thank our faculty advisor, Professor Baxter, who just came back into the screen. She is the backbone of Moot Court. She is the reason why every time we make a phenomenal decision is because we're able to have Professor Baxter guide us. And without her, this competition, Moot Court, is just not possible. And I'm so grateful to have her wisdom and her guidance. So now that we have our panel back.
Yes, we have reached a decision. Lakshmi, would you like to announce our other awards from today? Wonderful. For those of you watching, we have been competing all morning and all afternoon, and these competitors have given so much of their time, not only the 2 teams on your screen, but every team that has competed throughout this competition. So with that being said, we have a couple of awards to give out for Best Oral Advocate and Best Brief, and then we're going to recognize a few others as well. So Lakshmi, please take it away. And after that, we will get into brief feedback, and we're going to announce our 2022 Intramural winner.
Thank you to my awesome co-counsel, Kelly. So I'm actually going to share my screen, and you guys are going to see the winner for the Best Brief Award of the entire competition is the Wolfpack. So proud of you guys. Okay, and now I am going to share my screen one more time, so get ready for that. We are going to announce the Best Oral Advocate. This competitor got 10s, sometimes almost across the board, and we definitely wanted to recognize her because she is phenomenal. To our Best Oral Advocate, Arlette Gomez. Phenomenal. And that is all for me. I'll turn it over to our Chief Justice.
Thank you so much, and congratulations to the Wolfpack, and congratulations to Arlette. With that, I'm going to turn it over to Justice Marino, and she is going to provide feedback. We're going to go through very quickly and generally, and then I will announce a winner.
Thank you so much, Ms. O'Neill. Students, congratulations on completing the final round. You appeared before an extremely hot bench, many of its members maintaining very strident opinions regarding this area of law. And it is challenging for even the most seasoned among lawyers to be able to maintain composure and respond as well as you did to our questions. So thank you so very much for your wonderful performances today. And I wish you the best of luck in the rest of your legal education and as practicing lawyers. And I guess I will popcorn it now to Justice Baxter.
Okay, thank you. Thank you, Justice Marino. Quickly, I'm not going to go through one by one. I was blown away by every single one of your performances. You were amazing. There's no question in my mind how you made it to this final round. And if you have not, and if you are still eligible to compete, I know many of you are 3Ls, and I'm so sad about that because I wish you had competed for us for Moot Court. But any 2Ls there, I hope you are seriously considering competing for Moot Court. So I just got to put that out there as my plea as the faculty advisor, because all of you were fantastic. It was a really tough decision, really, really hard for us. I'm just going to give a special shout out to the rebuttal, George. I just thought that was great. It wasn't just because you referenced me. Just kidding. But I do think that's a really great skill to make sure you reference something that actually happened in the oral argument. Great job. You were all amazing. And I'm going to popcorn it to Justice Sepler.
Okay, well, thank you. I'm going to even be more brief. I'll tell you all, I've been doing this for a very long time, and it's a real honor for me to have listened to the four of you. I know that you are juggling classes and maybe work and whatever you're juggling, and to be able to put the kind of work in that you did is remarkable. And the fact that you can understand the problem and convey your arguments as well as you did. You know, one of the things that I've always felt about appellate arguments, it's not, obviously it's not like a trial, so there's no emotion, but your conviction and your belief in your position really comes across in appellate arguments. You're trying to move us, and I think the four of you absolutely did that. So I'm going to send it over to someone else, but I want to again thank you all for a wonderful afternoon. Now, who am I going to send it over to? Who's next? Who hasn't gone? Of the judges. Where are the other judges?
Villanueva, do you want to go ahead?
Yeah. Justice Abin.
Okay, sure. I'll also keep it brief. I have seen most of you argue as, you know, from before, different competitions. And for me, I like the most that I could see your progression. Some of you, I saw you the first time you argued in Fine Writer till today. And I can say that for every single one of you that I have seen, I've seen an amazing improvement. And for those who I haven't seen, I was impressed. And I think that Moot Court and this competition is only to your advantage. So keep using these tools and listen to whatever Professor Baxter advises you to do.
Yeah, popcorn it to our last justice, Justice Perez Villanueva.
Thank you. Save the best for last. Just kidding. Well, I want to echo the sentiments of all my colleagues on the bench today, and just I'm so grateful for the opportunity to have witnessed this. Maybe a little painfully so, remembering my own performance when I was in your shoes. It wasn't as eloquent or professional, but I do want to say that it certainly it's better than a lot of performances or a lot of lawyers that I've seen when I was on the bench appear before me. So I think you all have a tremendous head start in your careers in advocacy. And again, I am very grateful for the opportunity to have participated in this.
Well, that concludes our feedback. Congratulations to all. Seriously, Anna, George, Ashley, Alessio, and Jake. I'm sure a lot of you have seen Jake on the screen today and you're kind of confused. But Jake is also a member of the Wolfpack team. They are named the Wolfpack because they are our only team of 3. So congratulations to everyone for making it to this point. And without further ado, I am so pleased to announce the winner of the 2022 Intramural competition. Not only did they win the Best Brief Award, but they came out and won it all, the Wolfpack. Congratulations, guys. It was so close.
Congratulations.
Thank you all, and thank you all for judging this final round for us and being here with us on a Saturday. We really appreciate it.
Well, we appreciate you, your work, all of you, seriously, both teams, your efforts, they're so evident. And we look so forward to watching you continue to grow into your inevitably successful careers and your future with Moot Court if you're still around next year.
Thank you so much, everyone, for the compliments and the nice word. It was extremely difficult for me because I'm not English native speaker. So when I receive question, I really have to think not only about the answer, but also how to formulate a proper sentence in English. So I'm really proud and happy. Thank you, everyone.
Thank you. And that's going to conclude our live stream for today. Thank you all for tuning in. It means so much to our competitors to watch their journeys. I'm sure many of you have been tuning in for the past couple of years that we've been online, and to see us reach this point is just, it's truly been an honor to watch the society grow. So from all of us here at the Moot Court Honor Society, thank you so much. Thank you to our judges. Thank you to our faculty advisor, Professor Baxter, and thank you to the administration, Dean Juarez, who makes all of this possible. Thank you so much. And we look forward to seeing you all very soon for our upcoming Fine Writer competition.